Have you ever wondered what redundancy means in the Kenyan employment landscape? Or perhaps you're curious about the legal provisions surrounding this term? Well, let's dive in and demystify this concept. In the Kenyan context, the Employment Act defines redundancy as the loss of employment, job, or career by involuntary means through no fault of an employee, where the employer initiates the termination because the services of the employee are no longer needed. This can also be due to the abolition of an office, job, or occupation. Now, the question arises, can an employer just declare an employee redundant at will? According to Section 40 of the Employment Act, there are several conditions an employer must meet before terminating a contract of service on account of redundancy. Firstly, if the employee is a member of a trade union, the employer must notify the union and the labor officer in charge of the area where the employee works about the intended redundancy a month prior to the termination date. Secondly, if the employee is not a member of any trade union, the employer must notify the employee personally in writing and also the labor officer. Thirdly, the employer must consider several factors while selecting the employees to be declared redundant. These include seniority, skill, ability, and reliability of each employee affected by the redundancy. In cases where there's a collective bargaining agreement between the employer and a trade union, outlining terminal benefits payable upon redundancy, the employer must not place the employee at a disadvantage for being or not being a member of the trade union. Moreover, if an employee who is declared redundant is due leave, the employer must pay off the leave in cash. The employer is also obligated to give an employee declared redundant not less than 1 month's notice or 1 month's wages in lieu of notice. Lastly, the employer must also pay severance pay to an employee declared redundant at the rate of not less than 15 days' pay for each completed year of service. The courts have interpreted these provisions in various cases. For instance, in the case of Ignas Karingo Magona and AMP 4 others v. Star of Hope International Foundation, Justice Rika discussed Section 40 of the Act in relation to redundancy, emphasizing the need for the employer to give a notice of not less than 30 days prior to the intended termination. The notice must reveal the reasons for and extent of redundancy. In conclusion, redundancy in Kenya is not just a simple matter of an employer deciding to let an employee go. There are legal provisions to ensure that the process is fair and transparent, protecting the rights of the employee. The law requires that the employer follows a due process, notifies the relevant parties, considers specific factors in selecting employees for redundancy, and pays the appropriate terminal benefits. If you feel you have been terminated unfairly, contact us at free-legal-advice-kenya.com or send a WhatsApp message to 0703469511.